Welcome to join our event. I'm Monica Young. I am the Global Real Estate Investor Club host, as well as I'm the broker of Just Global Inc. As an investor club, we have been hosting events, especially educational events, on a monthly basis since 2003. And we really appreciate the support of everybody who logs in today, who are our members, as well as our clients or people who are interested, or David's friends or David's clients who log in to hear us today. So today's presentation, we're going to have two parts. The first part is going to be a market update about Bay Area real estate trends, as well as the mortgage interest status. And then the second part of it, of course, we're excited to have Mr. David Bonaccorsi to provide an update on the tenant rent deferral moratorium. So we have better insight, and we could also relate questions for Dave at the end of his presentation. So first line, please. So being a real estate broker, we've been in this business for over 20 plus years. Together as a team, we have over 40 years of experience. And real estate being one of the largest investments in one's life, we think it's very, very important to make good plans as well as to be educated. So as a club organizer, so we have organized a lot of good information events, inviting lawyers, CPAs, property manager to provide information for our members, clients who are landlords or owners. And we are definitely, very dedicated, committed for the real estate business. And I'm a broker of Just Global Inc. So we have noticed that since the shelter-in-place listing has been really going down, like in March, that you're going to see some statistics been going on significantly, close to 50%. In recent months, actually improved. The listing dropped down about 23%. However, we're still seeing a lot of good buyers. Like I have mentioned, because of the low interest rate, the demand for housing, especially in good school area, is very, very positive. And also home with very big lots, also very hot. However, for townhome and condos, they are slowing down in sale. And at the same time, we have some clients actually, because they can work remotely, and people are moving further away into the suburb area, and they can telecommute. Next slide. So this gives you an idea about statistics that happened in the last few months, say March, April, and May, and you can see that a lot of new listings have been dropped significantly. But we see some improvement in May. Actually, it's not as bad as in other months. Like April, we dropped 45%. In May, we have like a 23% year-to-year difference. And also, in terms of contingent listing, we also see some drop, like pending drop about 31%, and closed sales actually dropped 54%. So overall, it's not just in the Bay Area, but throughout, like California, we see the slowdown in sales. Next slide. So in terms of mortgage payment, you can see that we are actually at one of the historic low right now. And the mortgage rate is about 3.23%. And in terms of mortgage payment, if you are a homeowner, you can see that you would have good saving up to like double digits, 13.2%. So if you have not done refinance yet, it's the time for you to look at it. Definitely, it's going to save you a lot of money. Next slide. So just to give you an idea, so we closed a number of deals recently for jumbo loan for a 30-year fixed rate, especially if it is a purchase. It can be as low as 3%. And 10-1 adjustable rate is about 2.5% for purchase. And why I mentioned about purchase, because you would get some bonus if you are doing a purchase loan. And then for the high balance conforming, which is $510,000 to $765,000, it could be as low as like 3%, of course, depending on your loan amount. And this rate that we mentioned actually would be able to cover some of the closing costs, or, no closing costs at all. And for $510,000, which is a conforming loan, you see actually a dramatic low rate of 2.875% for 30-year fixed. Next slide. So in terms of pending sales, like I mentioned, during the shelter-in-place time, the market has been slow. But gradually, as we open up, now we are able to show houses with mask and gloves. The pending sales actually has rebounded to be about like negative 5.5%. Next. And also for the higher end property, in terms of like, say, if it is, say, $1 million to about $3 million, especially, you can see a 25.1% jump. And it's not just in California, a lot of major cities like New York. And I actually heard that like people are moving from Manhattan to suburban area like New Jersey or Connecticut for bigger homes, because a lot of college kids would have come back home while in shelter in place. In the Bay Area, we also have clients moving from San Jose or the Mid-Peninsula to live in places like Denver or San Ramon for bigger homes and more affordable price. Next. So like there has been survey conducted and say asking if it is a good time to buy a home in California. They're about like 32% of people think it's a good time, especially if you want to save on the interest rate. When the interest rate dropped by 1%, say last year if it is about 3.5%, now this year 2.5%, essentially you save about 10% on the purchase price. So it's significantly bigger flexibility for buying a bigger home, you know, even with the same payment because of the low interest rate. And then also, do you think it's a good time to sell the home? We've been actually having a number of clients to sell in this market. In fact, this morning at 9 a.m., I just have a homeowner. We put a Sunnyvale home into contract and, you know, sold it over, say, 20% over asking. And now they're on the way flying to Florida for retirement. So there's been some movement. So if you're thinking about selling the home, it might be a good time because there's still a lot of buyers there and inventory is very tight, especially also interest rate is at historical low. Next, please. So list price trend suggested is still pending up. So we see a lot of activities for people looking at homes. And in fact, I just talked to a client yesterday, like the two daughters who are working in tech, they work from home and the mom is trying to help them to buy a home so that they can ride on this low interest rate boom. So it's definitely, you know, we see the list price actually has been gradually, you know, like coming up stable because of the low inventory. Next. And medium home price, you can also see the medium home price growth, you know, for $1 million plus property, and people looking for bigger home, nicer area, and also if you're buying in a good school area, definitely it's going to preserve value. So we've seen like Cupertino schools, Sunnyvale schools, and also, you know, like Mountain View are very, very hot areas. That's still a lot of tech buyers out there shopping. Next one. So recently, we have closed on a number of properties. Like I mentioned, you know, like the Sunnyvale home, which is 1,400 square feet. We listed it at $1.85 million, and we got like 6 offers, and it was overbid to $2.05 million. So it's a significant overbid for like $200,000. And then also we closed on one in Denver, and it's a 4,000 square feet home. So if for $1.6 million, if my client's trying to buy one in the Mid-Peninsula, they might be able to get like a 1,500, 1,700 home. And then if they would be able to work remotely, they can live in Denver and then at the same time have a very, very good sized home. And then at the same time, others, you know, I have like closed in Sunnyvale Townhome is a very nice home for, you know, like a small family, but because all 3 schools are good, like they have Cumberland, they have like Sunnyvale Middle, as well as Homestead High. So it's a 1.2 million is a good size. And also Campbell, we also closed on a detached townhome, which is a very unusual that have detached on both sides. You know, a townhome for $881,000, I think is a very good deal. Next one. So in Cupertino, we have a house that's listed as $2.39 million. I bought it for an investor back 5 years ago at less than $2 million, and it does have good appreciation. And we do have like 5 offers on this, and it overbid to $2.57 million. So you can see that good schools are always in demand regardless of the market situation. Next one. And we do have one coming up, and that is in Milpitas. And also, again, good schools for any family who are thinking about having a starter home, 4-bedroom, 2-bath, which is good because we've noticed that a lot of people are looking for more bedrooms because they work from home. And schools are good. It's elementary scoring 9, and then 8, and then 10 for high school. So basically, it would be, I think it should have very good demand, and it would come on the market in about 2 weeks. Next one. So we actually just got into contract for like an uplift of this home. The owner itself, they're currently living in a 2,400 square feet home in San Leandro, and they're moving to Castro Valley, which is nicer school and also a big home for 3,500 square feet. And we got in contract for 1.38 million, and they're selling their primary. We have not fixed the price yet, but definitely you can see that people are trading up for nicer area and bigger home. Next one. So this is actually a rental right now. The tenant's still living in it. They're in the process of trying to work with the tenant. I guess, you know, for homes like this, it's probably during COVID-19, we will not be able to invite them out. So they have a solution either to sell the home with the tenant or, you know, wait to like the state of emergency to be over. So next one. So this is a San Jose home. It's being remodeled, and it's 1240 in the Campbell-Cambrian area with a big lot. And we've noticed that a lot of clients now are interested to build ADU, which is accessory dwelling unit in the back, either for getting more rental income or maybe for the future, say, aging parents use, or, you know, for adult kids to use it. So the big lot home is highly, highly popular. Next one. So like being an investor club, we also provide a lot of opportunity to invest in out of state. And you might have heard, well, one of the talk of the town is Tesla has bought 2,100 acres outside Austin, and they also able to secure 60 million tax incentive from the Travis County, and also from the Deferral School District. They got 68 million of taxes waived within 10 years. So I think, you know, Tesla, I was told that 99% decided to move to Austin. So if you're interested to talk more real estate while you're thinking about, like, say, California may be a bit expensive, you can consider talk to us, you know, like in terms of investing in out of state. You know, like for a mid 200,000, you can get a single family home brand new, and would be able to get $1 per square foot rent. And the market's very, very hot. Yeah, so talk to us if you are interested. Next slide. So again, just to wrap it up, this is our contact. And if you have not worked with us before or you have not attended our event, please make sure that you sign up for our e-newsletter, because we do monthly events and providing a lot of update on the market and good information about the national real estate trend. And of course, we have good speaker like Dave, who would be able to share with us some of the key issues in the area. So just finish that part of my presentation. And without further ado, we would like to have Dave to be coming online, and he's already online, to speak to us about the tenant rent moratorium. And Dave, you know, like, can you give us a little introduction and background about yourself? Because definitely we'd like to hear more from you.
Good morning, Monica. How are you? Thank you for introducing me.
Great, thank you.
For your wonderful presentation. For my friends that don't know the Global Real Estate Investors Club, that was Monica Yoon, who has been leading the charge for many, many years. In fact, we did a presentation back probably about 10 or 11 years ago. And so we've reconnected during this moratorium. I grew up in Fremont, but for our friends at the Global Real Estate Investors Club, I have a strong Santa Clara County connection. I went to undergraduate and law school at Santa Clara University. So I was down there for about 7 years and really enjoyed my time at that wonderful institution. And I've been practicing law in the Fremont, Newark area since 1987. And augmenting that, I've had the privilege of serving on our Fremont Planning Commission for 10 years. And then I had a 2-year stint on the city council for Fremont. And why that's significant, I think, today is I understand both the legal aspects of these moratoriums and ordinances that are being passed, but I also understand some of the political policy tensions and dynamics that are at work right now that I think adds some context to what we're seeing and maybe provide some predictive value as to what we're going to see ahead. So, Carl, if you could proceed with my first slide, please. When we're understanding what is happening here for tenant evictions and rent deferrals in our local communities, there are really 4 major players that are going on in parallel. First, the governor, and with executive orders, and we'll discuss that in a second. The counties and cities with the benefit of executive order authority to enact moratoriums and ordinances concerning tenant evictions. The governor again stepped in early on and had a statewide ban on residential evictions during COVID. But Monica, we did this back on April 18th, and a lot has changed since then, and more than the 2 months since we did this presentation, nearly 3 months. His statewide ban ended on May 31st. So the governor has gotten out of the business of trying to regulate tenant evictions and rent deferrals during COVID and left that to the counties and cities. And then I'll be talking about a significant game changer from the California Judicial Council back on April 6th, which hangs like a dark cloud over everything else we're talking about in terms of local moratoriums. Next slide. Back on March 4th, Governor Newsom declared a COVID-19 state of emergency. That proclamation or declaration is significant not only for the ability of California to obtain certain federal relief, but you'll see that in various moratoriums that we're considering, that acts as an important metric or baseline to determine how long some of these moratoriums are going to remain in effect. And right now, it's still in effect. And maybe had we done this back in April, I would have been optimistic that by July or August, we would have flattened the COVID curve and done everything right. And maybe there would be a light at the end of the tunnel, and maybe the governor would lift that state of emergency. Unfortunately, we're going in the reverse direction, and all the benefits that we obtained for shelter in place and lockdown in March and April have been unwound by, frankly, opening up the economy a little bit too soon without adequate testing, contact tracers, and all these other things that our epidemiologists say that we need. And just last night in Alameda County, the governor or the state public health official stepped in and said to Alameda County, yes, you had outdoor dining, but because your numbers are not good, we're going to shut that down. So it may be a little bit better in Santa Clara County. It had been worse. Santa Clara County is now better than Alameda County, but at least in Alameda County, we can't have outdoor dining right now for the foreseeable future. That all impacts on the fact that we still have a significant state of emergency with no end in sight as to when that may be lifted. On March 16th, the governor issued a very important executive order, EO N-2820. What he did is he authorized counties and cities to be able to enact these kind of rent ban moratoriums or eviction ban moratoriums and deferred rent for both residential and commercial tenants. Initially, it was through May 31st, and on May 29th, he extended that period up to July 28th. And without that executive authority, counties and cities would not ordinarily have the power to enact the moratoriums and ordinances that we're going to be discussing today. So as long as that executive order is in place and has not expired, the cities and counties are free to enact or renew or extend their own local moratoriums. Next slide. Obviously, once the governor gave the counties and cities permission to do so, the counties and cities stepped in. Alameda County and San Mateo County have a commercial moratorium, but that only applies in unincorporated parts of the county. And just as a primer for people that may or may not understand the differences, when you live in a city, you live in an incorporated municipality. When you live, for example, in Alameda County, if you live in Castro Valley or Sonol, those are communities that have a name, but they're not cities. They're unincorporated areas of the county. So typically, counties regulate only the unincorporated areas. The sheriff's departments in a county typically only deal with law enforcement in unincorporated sections. But with the emergency powers that the governor gave during this COVID crisis, and the counties and cities have believe that they have because of the public health crisis, they're now enacting ordinances that apply across the board. So, for example, in Alameda County, they stepped in and have an ordinance that applies throughout the county. And even though places like Fremont and Hayward and other cities before the county stepped in had enacted their own residential eviction bans. So really in Alameda County, the first place and the only place to go to if you're a residential landlord to know what your rights and obligations are is to understand and fully understand the implications of the Alameda County ordinance. Santa Clara and San Mateo County, or at least Santa Clara County, has a residential and commercial ordinance that applies across the board and applies to both cities and unincorporated areas. Next slide, please. Again, these are some of the cities that had opened up after the executive order and enacted ordinances. And if you look at the ones in Alameda County, if they're residential ordinances, they really no longer have any effect because of the county ordinance. And these are some of the ones in Santa Clara County. And for example, there's one in San Jose. And what Santa Clara County has done is that you compare them. And I'll describe that comparing process. So it's not automatically eliminated San Jose's residential ban as they have in Alameda County. Next slide. This was the game changer. On April 6th, there is a organization called the California Judicial Council, and it's presided over by the Chief Justice of the United States, not the United States, but the California Supreme Court. And on April 6th, they adopted an emergency rule which remains in effect. It prohibits a court from issuing a summons in eviction cases. Well, what's the summons? If you've had a tenant that hasn't paid rent, everyone knows about the 3-day notice to pay rent or quit. And if they don't pay their rent within the 3-day notice, then you go to court and file a lawsuit. Well, when you go to court and file a lawsuit, you need the court clerk to issue you a summons. That says by the court that the court has authority over this case so that you can proceed to go to trial if necessary. Well, what the judge said statewide is we're not going to allow the county clerks to issue a summons in all landlord-tenant cases, whether commercial or residential, just whether it's COVID related or not. And that's going to apply until 90 days after the SOE, the state of emergency, is lifted by the governor. If you recall a few minutes ago, I said the state of emergency is in place and it will remain in place. So I know at least this is my 7th webinar that I've done since COVID in place. And what it does is what invariably happens is I'll get questions about, well, I want to go to court. And the answer in the short term is you can't for non-payment of rent. Next slide, please. These are some of the other parts of the order, which is that there's no entry of default until 90 days. So if you were a lucky landlord and had served your tenant before shelter in place but hadn't gotten to the court to file an entry of default, you'll have to wait until 90 days after. So you have a tenant there that hasn't paid rent and may not pay rent for a long period of time. There's some other restrictions, and one of the things I know that Monica will do is we'll send out the PowerPoint, and you'll have this in your back pocket, so you can go look at the other restrictions here. Next slide, please. What's now true after the CJC, California Judicial Council emergency orders? What's true about eviction moratorium? They do typically 4 things. They allow residential and commercial tenants to be able to defer rent. So in most instances, in most of these moratoriums, if you're not paying rent in April, as a tenant, April, May, June, and now July, these ordinances say you'll have to pay it sometime later, but not now. And then there's a time frame over which period they can pay it back and how much they can pay back. And then by definition, they can't be subject to termination. You can't terminate the lease for non-payment of rent. Eligible tenants eviction proceedings are delayed, but again, the California Judicial Council order now controls the statewide 90-day hold until after the state of emergency is lifted. And it really creates two classes of tenants in some jurisdictions. Those that are eligible, that qualify for COVID relief. They've lost a job, or they're a small business and they've had shelter-in-place orders and they can't open their doors or generate the same revenue because they can't have people dining in if they're a restaurant. And then there's non-eligible ones, people that are still working in the high-tech industries that might be bidding on one of the homes that Monica is listing for sale in Cupertino or in San Leandro. They are still obligated to pay rent, but if they don't, the importance and the power of the California Judicial Council order hangs overhead. You can't do anything as a landlord. You can serve a 3-day notice, but you can't go to court to evict and retake possession. Next slide. What now for tenants who are ineligible? In theory, you can serve pre-litigation termination notices, but I say let's be practical again because of the California Judicial Council emergency orders. You serve a 3-day notice to pay rent or quit. If you take rent after that period, it invalidates your 3-day notice. You've waived the right anyways. So the only way to preserve your 3-day notice to say, well, I've got this tenant who's not paid the last 3 months and I can't wait until I can go to court. You don't know when you're going to be able to go to court. You could be waiting 6 or 7 months at realizing you can't take rent in order to avoid having to serve another 3-day notice to pay rent. So I'm thinking, and I'm suggesting to landlords that you're going to have to look at the long time horizon and not try to issue them, even though theoretically you could. Then there's AB 1482, which is the Tenant Protection Act of 2019, that if you have a tenant that's been there for more than 12 months in areas where there's not already a just cause or rent control jurisdiction, there's a new law that went into effect on January 1st of 2020, and there's some restrictions on the ability of landlords to evict. There is an opportunity for rent to be collected from a commercial tenant after a 3-day notice is collected, but those rules differ, and I would want to look at the lease and look at the jurisdiction and see what your restrictions are. Next slide, please. For residential tenants who are eligible to claim deferrals, this is the question you have to ask if you have a tenant. Where is your residential property located? What county, what city? And then you have to ask these questions and ideally consult with an attorney to get a definitive answer. But really where you have to start is, does the county have an eviction ban and allow rent deferral? If so, is it in the unincorporated part of the county? The county rules will apply. Does the city have an eviction ban and allow rent deferral? Then you have to go to the next question. You may have the city and county both have eviction bans that allow rent deferrals. Which one applies? In Santa Clara and San Mateo counties, actually in Santa Clara County, it's whichever rules favor the tenant more. San Mateo County, there's only for unincorporated areas. In Alameda County, the county rules apply unless the city opts out. Now, there's no city that in Alameda County that has opted out, and I don't think that they can, because they would have to show that their local rent bans or eviction bans are more tenant friendly. The counties is one of the most tenant friendly ordinances I've seen. I've read a number of them up and down the state, and there's a lot of reasons for that. There's none of the ones in the county that exist right now are more tenant friendly. So for the foreseeable future, the only rules in Alameda County that apply, as I said earlier, are the Alameda County ordinance that was enacted on June 23rd. In Contra Costa County, I thought that they took a very, from a policy-making perspective, I thought that they took a much more prudent approach. There's a county ordinance, but the county ordinance explicitly says we're not going to compare and contrast. We're not going to see which one's stronger. We're not going to put landlords in the position of trying to act like judges and interpret conflicting ordinances to figure out which is most tenant friendly. Just follow the city ordinance. So in Contra Costa County, yes, there's a county-wide ordinance that applies to both the unincorporated areas and to the cities, but in Concord, there's a city ordinance. So simply follow the city ordinance in Concord. We try to have Alameda County do the same. They were not interested in doing that.
放在那个没有，我已经捐给他们了，那个修车厂了吧？
After, for the commercial tenants, the same thing. You have to do the comparison, whichever favors the tenant, if there's both a city and a county one. In Alameda County, as I said earlier, in San Mateo County, the commercial ordinances don't apply to the city, so you follow the city's ordinance if they have one. And in Contra Costa County, same thing. If the city has an ordinance, follow the city ordinance, even though there's a Contra Costa County commercial ordinance. If there's not a city ordinance, then the Contra Costa County rules for your small businesses will apply. Next slide. Here I'm going to give you an example because we're in Santa Clara County. I'm going to give you one more a deep dive into what a moratorium looks like for residential small business tenants. They're similar in scope, very similar standards in other counties, but they do have important differences and each has some unique qualities. In Santa Clara County, the tenant is to document in order to be eligible for not being evicted from their place, in order to be eligible for deferring their rent, they need to document it either by a job loss or a layoff or reduction in compensable work hours. If you're a store, business, or restaurant, you can show that you've been closed or a substantial decrease in business income. So even if you remain open, you know, invariably, if you've been a restaurant that cannot have indoor dining, it's I'm sure you're going to be able to easily show that you've had a substantial decrease in business income. Or on the other hand, if you had to miss work to care for a homebound school-age child, in Fremont last night, the school board said that it's only going to be distance learning until Alameda County shows no rate of infection for 7 days in a row. Well, that may be for a long time. So you may have tenants in Alameda County that says, I got to stay home in Fremont to take care of my child because they can't go to school. That will be a ground in Alameda County as well as in Santa Clara County as a basis for not having to pay rent or pay reduced rent. And then on the other flip side is if there's been a substantial increase in out-of-pocket medical expenses. If somebody's uninsured or underinsured and they're getting costly treatment because of COVID, that's a basis for invoking the protections, tenant protections for these moratoriums. What is considered a small business? And again, it differs from county to county and from city to city. But in Santa Clara County, you look at the Small Business Administration table of size standards, and they refer you to a Code of Federal Regulations. Now, again, I think this is a lot of hard work for landlords that that may not be sophisticated, and tenants who may not be sophisticated. You have to basically go to a CPA maybe to figure out, are you a small business? But that could be in Santa Clara County, a small business could be generating as much as $25 million in revenues per year. And if it's in the right industry and under the right classification, it's still considered a small business and could invoke the commercial protections in Santa Clara County. Fremont, I thought took a smarter approach. Rather than look at some external standards in terms of determining what is a small business, they simply set a flat amount of no more than $8 million in revenues per year. So I thought that was a much more pragmatic, common sense approach. And it really does try to reach down and protect small businesses. But one might have to ask the question, as a policy matter, if there's COVID, there's really, there may be very substantial losses even if you're a large business as a tenant. So I think this is where politics, public policy, and the law kind of intersect. There would have been more support and less opposition if we were trying to protect small business by councils and counties than having across the board moratoriums for large businesses on the thought that landlords are going to say, well, why should this large company that should have reserves get out from paying rent? We need the rent. Next slide, please. Santa Clara County. This is how it works. If you're eligible as a tenant, the rent's deferred up to 120 days after the current July 28th, 2020 expiration. Remember at the beginning of my presentation, I mentioned the governor gave the county's authority and the city's authority to enact legislation, but it now expires on July 28th. So if you have a tenant in Santa Clara County, they can defer rent for rent that was due up through July. Or extended by the Board of Supervisors. Well, that means that they're going to extend it presumably only as long as the governor allows them authority. So if on July 27th, the governor extends the authority of counties to do this another couple of months, I'm sure the Board of Supervisors, they've done it once already, I'm sure they'll extend it again, because the original ordinances in the county had expired on May 31st. Once the governor extended the deadline from May 31st to July 28th, the county of Santa Clara followed suit. The notice of termination. This is really important. You can really get tripped up depending upon which county you're in on how to do the notice of tenants' rights. And if you just use your standard notice of termination and don't follow the county ordinance, your notice will be invalid. Even if the tenant didn't declare that they were not eligible and didn't do what they needed to do to declare eligibility. So you really need to know the county ordinances. In Alameda County, for example, if you sent out a notice of termination for a residential tenant, you still have to include a copy of the ordinance from the city that you're in, which to me is just nuts. And that's not a legal word, it's just my reaction. The reason is, for example, if you're in Fremont, and I know a few of my friends here are watching and either live or have property in Fremont, if you have a tenant that's in Fremont, I already said the Fremont ordinance for residential tenants no longer applies because the county ordinance is a lot stronger, and so that's the only ordinance to apply. But the county of Alameda still requires you to include in your notice of termination a copy of the Fremont ordinance. So what's the poor tenant going to do? He's going to look at it and says, well, what rules do I have to follow? And I'm confused. The landlord might think, well, I'm being a good landlord and following Alameda County. I understand that. But forget to include the Fremont ordinance for a Fremont tenant. That notice of termination will be invalid. So it's a trap for the unwary. It's a lot of these ordinances really are going to be easily violated, and that's going to result in a lot of unsuccessful evictions, even when the state of emergency is lifted and we can go back into court. Again, if the tenant is eligible, the owner cannot terminate a tenancy for non-payment of rent or no-fault eviction. There may be instances where you could, at least in theory, send out notice of termination for non-monetary violations, breaches of covenants, like a no pet clause or a violation of the obligation not to sublet without the prior written consent of the landlord. But it just gets you to the point where you've perfected a notice of termination. But as long as the California Judicial Council order is in effect, you can't get to court to pursue it. Next slide. I'm going to show you now what in Santa Clara County, at least, you need to show. And they're on the website. And at least if you're in Santa Clara County, I think in balance, I think it's really good that they provide you the form. You don't have to guess. You don't have to include the right information. They provide the pre-printed form for you to be able to use. So let's look at these forms in Santa Clara County. This is a required statement of reason for termination of tenancy and a notice of tenants' rights. This is the Santa Clara County ordinance for eviction bans and rent deferral. And it explains to the tenant when you're serving the notice. In theory, If you had no contact with your tenant and didn't know whether they were COVID qualified, this is what you do. You're dissuaded, and you should not be serving a notice if the tenant has notified you, and better yet, documented even before they gave you the notice, because you're already being put on notice as the landlord that you cannot proceed because of tenant protection. And then you have to state your reason for termination, okay? And it has to be supplied. You fill it in. Next slide, please. This has to be included with the notice, the required statement of reasons for termination of tenancy or evictions. And this is basically a cheat sheet, and I don't mean that pejoratively or negatively, but this is kind of telling the tenant, okay, if you haven't invoked COVID relief, there's a county ordinance. This is what you need to show because you have a substantial loss of income and you're unable to pay rent. On the other hand, because you've got a substantial out-of-pocket medical expenses. So it's educating the tenant to invoke this moratorium if they're entitled to it. Then there is a list of frequently asked questions to educate the tenant. And as part of the ordinance, there's supposed to be a list of emergency rental assistance programs available on the county website. You're to provide that to the tenant and to encourage them, frankly, to say, hey, look, there may be something you're eligible. You can pay some of the rent, so you don't have to defer all of the rent, and you're not going to dig too deep a hole for yourself. And we're not going to have to try to play catch up after the moratorium is lifted to a high degree. Next slide, please. This is what the tenant fills out, okay? And they're entitled to give this to the landlord to say, I'm eligible. If this, you can check the boxes. Why have I as a tenant been substantially negatively impacted by COVID-19? Check all that apply. And then document it. But this is kind of interesting. It says, documentation for items selected above is attached, yes or no. So the county is taking a very tenant-friendly position that the tenant can say, I've got documentation, but doesn't have to show it. Now, I would hope that tenants would show you the documentation so you don't think that they're deceiving you or invoking it improperly. And in Alameda County, for example, you do have to show documentation, but it can be as simple as saying under penalty of perjury, I as a tenant have been impacted by COVID and no other documentation. We can go into the policy reasons for that, and it's on a timetable of 30 days, 45 days after landlord notice, or 30 days after the lifting of the emergency, whichever is later. Next slide, please. Okay, this is what I would like to talk. We can have a lot of discussion afterwards as we wrap this up, and I start taking your questions. I had done a presentation about AB 828 about a month ago, and then in early June I said AB 828 is dead. It's dead in the water. And then I received something earlier this week that it's still alive. Most of you who are landlords have heard about it. What it did in its original version was it was going to allow tenants that never invoked COVID relief during the moratorium, during the shelter emergency or state of emergency, and even if there was a moratorium eviction ban in their county or city, never documented, never gave notice to the landlord, they could show up for the first time in court once the landlord can get in court and said, I was affected by COVID. And in the original version, the judge, if they found that the tenant was right, could reduce the rents by 25% per month. So not only would the landlord not be able to evict the tenant at that point and get possession, but would have to give the tenant up to 12 months with a reduction of rent of 25% per month. There was obviously howls of protests from the landlord community. And now I've seen in a recent version, they've changed that. So that if this version of AB 828 got passed and signed into law, and it's not law yet, the tenant would still be able to do all these things in court for the first time, but the tenant would have to pay the monthly rent then in place for 12 months. So they wouldn't get a 25% reduction. Plus, for all the months that they had not paid, they would be required to pay 10% of the amount due. So let me give you a hypothetical. Let's say that you have a tenant that for 5 months didn't pay $2,000 a month. They're $10,000 behind, and magically somehow at the end of the month the shelter emergency is lifted, and you were able to go to court right away, and all of these wonderful things. At trial, you'd have a judgment. You were going to try to get possession plus back rent of $10,000. The tenant, if they got their rights, would have to pay their $2,000 a month going forward, plus 10% of the $10,000. So they have to pay $1,000 of the $10,000 at 10% of $10,000. So they have to pay $3,000 a month. And as long as they did that up until paying off the deferred rent or back rent, plus the current rent, and they stay current, they could stay there for at least another 12 months. And what happens if the tenant trips and falls and misses a payment? There is a very strong landlord remedy, which is the landlord at that point can go in on a declaration and within 48 hours get a judgment entered and then have a writ issued, and the sheriff can go out and they can recover possession. So there is some balance to it. It's kind of there's going to be a lot of push and pull in the courtrooms as tenant groups advocating for tenants says, look, you're not going to get your possession today. Why don't we do a workout order? So it gives a leverage on the front end to the tenant, but it also creates a tripwire that the landlord could then quickly, within 48 hours of a non-payment, establish that and then get the possession without a trial for the trial, because it's the trade-off. The tenant avoids a trial, but then basically waives the right to a trial as a remedy to this provision. There is another feature. Monica and I just had a conversation yesterday, and I have a different answer for her if she was going to ask me the question today than I had yesterday. There are some, what's in it for us as landlords? The tenants are getting all these breaks, but we still have to pay mortgage payments. That's not fair. We're not getting our stream of income to be able to make our monthly mortgage payments. So there's some federally backed mortgages, Fannie Mae and Sallie Mae and Freddie Mac, that allow you to defer your mortgage payments for 60 days if you've deferred your rent for your tenants. It's a very narrow window. It's not very positive. There may have been some improvements with one of the CARES Acts, but there's only about 22 to 25% of all loans are backed federally. So what about the other 75% of loans? And I said to Monica yesterday, well, there's really nothing you can do. And that's still kind of true today, except if 828 passed and became law in its current form. Because the other part of 828 is it gives a fig leaf, I think, to the landlord community that would allow, let me step back. If you don't pay your mortgage payment, what happens? Eventually, the bank can foreclose on your property and you lose your property. Most foreclosures are called non-judicial foreclosures. Now, the California Judicial Council in its emergency order prohibited banks from going to court to pursue judicial foreclosures. But again, judicial foreclosures are really very rare. Maybe 5 or 10% of all foreclosures are judicial foreclosures. That involves a trial, that takes time. Banks are interested in recovering the property and being able to resell it to protect their collateral. So most foreclosures are what are called non-judicial foreclosures, where you have to record a notice of default. That's a required step under California law. It's on the property address and it starts the clock ticking for the lender or the lender's agent to go and publish a non-judicial foreclosure sale. Well, AB 28 would take away a required step and therefore stop all non-judicial foreclosures if it passed during the moratorium, during the shelter emergency, rather. And it would prevent county recorders from accepting notices of default. So in the chain of things a bank has to do that are required in order to perfect the right to enforce their rights to get the property back as collateral for non-payment of rent, they would prevent lenders, banks, from filing or recording notices of default. So that would provide some level of high stress protection to landlords that were on the brink of losing their property to a foreclosure. I mean, this is in extremis. This is not really dealing with the systemic problems of rent and income. And of course, rental income, it doesn't only result in payment to the lender, but it results in maintaining the property, other costs, property taxes. There's a number of things the landlord has to worry about. So it deals kind of in a, on one issue, but doesn't deal with the systemic issues. Now there's another bill called SB 1410. Senate Bill 1410 passed the Senate and is now in the Assembly, and this is likely to get passed into law. It is actually supported by the California Apartments Association. And so there is some support on both sides of the aisle from tenant groups and at least one landlord group. And what it would do, it's a very complicated process, but it requires the landlord to provide the tenant an agreement where the tenant can defer rent now and provides financial assistance up to 7 months to the landlord for rent, and up to 80% of the rent that was due, and for the rent that's deferred, allows at a point beginning on January 21st, 2024, to start being eligible for tax credits. And then the tenant, likewise, beginning on January 1st, 2024, in theory, is supposed to pay the state money instead of the landlord for the money that was not paid during this COVID crisis. So, and that would be a 10-year program from January 21st, 2024 to January 1st, 2034, 10 years for the tenant to make up rent, 10 years for landlords to be eligible for tax credits. Very complicated. That's about the extent of my understanding of this legislation. I'm not even sure all the legislators who are voting on it understand fully its implications. I read a press release by the author of the legislation, Lorena Gonzalez, and her press release was talking more about what a crisis we're in and we need to help everybody, and only had a little paragraph at the very end of her own press release as to what the bill does, which doesn't really fully cover what the bill does. So it's we need to really be vigilant as to what that will entail if it's signed into law. What do we need to look for going forward? San Jose extended its eviction moratorium to August 31st. Let's see if it extends it even further. They've had also citywide enacted a rent control ordinance where there can be no rent increases until the end of the year. July 28th, that important date from the governor, will he extend it further, allowing these moratoriums to go further in time. Obviously, the state of emergency is a big one. If that state of emergency is lifted, then you should contact your attorneys about gearing up for evictions, because the 90-day period will start running. I'm getting a very helpful chat from somebody I think has authority, and he said it twice, so I will take it as true, that Governor Newsom issued an executive order on June 30th extending authorization for local governments to halt eviction for renters through September 30th. So that snuck in there. Between his extension in May and the July 28th, there was one just about a week ago that I will need to read up on, but I believe this to be true. So already we know that for cities, at least, their moratoriums can exist through September 30th, and I will double check, but I think he's right. I talked about the limited relief under federally backed mortgages, and then there was a change in the payroll protection plan, where initially, if a small business qualified for a PPP loan, 75% was to go for payroll that the owner of the business needed to cover, and only 25% could be earmarked for rent and utilities. Well, they made an adjustment so that up to 40% of the loan can be spent on rent or utilities. And why is that important? Because if you spend it as a small business owner on areas such as payroll and for rent and utilities, then even though it's in theory a loan that has to be paid back with a 1% interest rate in a couple of months, if you use those funds and you can document to the SBA that you use those funds, or the IRS, you use those funds in the right way, then the loan is completely forgiven. So if you are a commercial landlord and you know that your tenant has gotten a PPP loan, that's an opportunity to say, hey, look, you know, why don't you make us a priority in terms of paying some of your rent at this point? If you want to stay in business, it's only going to be sustainable for you, and we need to work out something so that once you can open your doors again to the consuming public, you don't have such a deep hole to dig out of in terms of back rent. So this is, I believe now, Monica, we're going to be able to take questions, and I'm looking forward to hearing from you. Actually, Monica, let's just go back to the last slide. I didn't realize it was there. This is something that we can talk about, and this will be in your packet when we send out the emails. The moratoriums and the ordinances that defer rent and create all of this eligibility for tenants, or in Alameda County, I didn't mention this, but it's so tenant friendly that basically there's an eviction ban on all tenants, whether they're COVID eligible or not, because they took into account the California Judicial Commission Council's ban on being able to evict. So they just put everybody into the same pot in terms of eviction bans. What should you do? You know, what can you do? And this is an example of a sample payment plan agreement that has been provided by the California Apartment Association. I would have you have me or any other attorney review it before you submitted it to a tenant, because there's aspects of it, I think, that go beyond what a landlord should be able to do at this time. It really should be focused on rent, discounts, deferrals, payment plans that can be even more friendly, quote unquote, or more tenant friendly than what they're allowed under the ordinance. But if the idea is to allow the tenant to stay on their feet and they're really out of a job, you know, you're squeezing blood out of a stone, and really should be, it's not just simply being humanitarian, but it's being pragmatic and say, hey, look, what are some milestones for us to be able to get caught up? But I will be critical of this one aspect of it, which has a provision here that would require the tenant to make a promise or make a representation to the landlord in paragraph 5 that by entering this agreement, residents represent that the premises are in clean, safe, and habitable condition and free of needed repairs or damages. That's a gimme. That's a gimme from the tenants to the landlords that gives them gives away, I think, improperly their rights to assert the warranty of habitability that they would otherwise have. It's beyond the scope of the give and take, and I think that that would be viewed as a unenforceable provision, so I wouldn't stick it in there to begin with. If they have habitability issues, they should raise it, and they shouldn't feel like they're under duress to represent something that may or may not be true as a benefit for getting a deferred payment plan. So now I just wanted to give you kind of a practical approach that the California Apartment Associations has provided as a thought experiment for you when you're looking at having tenants that you cannot evict, frankly, for 6-9 months, who knows, until the state of emergency is lifted. I will add one more thing before we go to the Q&A that I did not mention at the beginning. And this was true since we had this happened only in June. It was not true when we were talking about the California Judicial Council emergency orders back on April 18th when we first had this presentation, Monica. But there has been a lawsuit filed by the Pacific Legal Foundation down in Kern County, challenging the authority of the Chief Justice and the California Judicial Commission to keep the courts closed for 90 days beyond the shelter emergency, state of emergency by the governor. Their view is that two things. The governor essentially gave limited authority, and they went beyond it. And even if the authority was granted properly, their alternative argument is that what the Judicial Commission did was act like a legislature and change the laws regulating landlord-tenant relations. So I have been in email contact with one of the attorneys for the Pacific Legal Foundation. I said, you know, what's your briefing schedule? When do you think you're going to get a result? He's looking, it's called a writ of mandate. It's a relatively quick process. You don't have a jury trial. It's really a glorified motion before a court. And that will be heard in September. And if it's adverse, if the Judicial Commission loses, they could do a couple of things. One, they could simply repeal their own ordinance in line with the writ of mandate, or they could appeal it, and maybe the Supreme Court would take it on an expedited basis. But that's also interesting from a point of view of judicial ethics. I imagine the Chief Justice, since she made the order, could not rule on it at the Supreme Court. So you'd have a missing chair, or they'd have to appoint somebody to hear it to join the other Supreme Court justices. So that's my presentation at this point. I'm